All right, last presentation was the fifth one of this series of lectures on world religions and modern secularism. And now we're going to move into a different aspect of seeing how this split right here has developed over time in the U.S. And we can trace this through court cases and in the U.S. But when we think about the founding of the U.S., one of the things that the founding fathers were concerned is they were trying to invent this new system of government, and they'd come out of the abuses of kings and queens who didn't allow freedom of religion. If the Protestant one was in power, they'd enforce Protestantism and persecute the others. And Catholic was it'd be the opposite direction. They had those type of things going on, but also the Enlightenment period. The founding of the U.S. was during the Enlightenment, so you had all this deism was there. You have Thomas Paine right in the middle of the founding of our nation, and the Revolutionary War in France as well. And so the founding fathers were aware of all this Enlightenment talk, and they read the philosophers of that time, and all these people that we've been discussing, they've been very familiar with it. And out of this, they were going to try to establish a new system of government. And so we'll see the effects to some extent of Enlightenment, but also the fact that they did it based on the fact that there would be a Christian moral foundation to this whole system. And but today, that understanding that as Christianity being a part of the moral foundation of our country is kind of pushed aside because of what they call the government has a separation of church and state. And so this idea of separation of church and state, which of course the Constitution doesn't say, but in some ways it's interpreted as saying that the founding fathers never intended for there to be any influence of Christianity or or religion as a whole, which is not really what the founding fathers intended, but we'll get into that more. So this idea of separation of church and state came about with a 20th century interpretation of the First Amendment, which requires a wall of separation between church and state, meaning it's not only prohibits the government from adopting a particular denomination or religion as official, but this is in violation of the Free Expression Clause, has regularly ruled to limit religious expression in the public sphere, from prayers in public school to passive displays of the Ten Commandments, which have been allowed for the first 150 years of the nation. And so we have to realize that this change in perspective, there's some historical dimensions to this. If we, I don't want to go there. So, oh, well, I guess I do. So if we go back to the First Amendment, Congress shall make no law restricting the establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of people to peaceably assemble and to petition the government for a redress of grievances. Well, everybody's in agreement that the government cannot establish a religion. So in other words, there can't be an official religion of the U.S. based on the First Amendment. But the second clause in that is, or prohibiting the free exercise thereof. This is where the problem lies, and various court interpretations have changed the meaning of this over time. The basically is saying the government can't prohibit the free exercise of our religion. We can't, we can exercise our religion wherever we want, however we want. That's a freedom we are given by our Constitution and the amendments, and just like freedom of speech. Now we do know that, if you do something saying, oh well, I'm going to kill people as part of my religion, that's going to be prohibited. Just like freedom of speech is, you can have freedom of speech, but you can't yell fire in a theater unless it really is a fire. Anything that would be harmful to the general community. But the exercise of religion was not seen as something that harmed the community of people or the people in the U.S. at that time. So you have your free exercise. It did not say only in the private sphere or freedom of speech in the private sphere. In other words, some people have taken it, well, you can privately exercise your religion, but you can't do it in the public. Well, it doesn't make that limitation here. And we don't make that limitation in freedom of speech. Why would we make that limitation in freedom of the exercise of your religion? But that's how it's being played out historically in the US, is that there's been a progression of limiting the exercise of religion in the public sphere. And so we're going to look at some of that as we go forward here. The landmark case was in 1947, case Everson v. Board of Education. The Supreme Court applied the Establishment Clause of the First Amendment to the states. This was when a taxpayer in New Jersey brought a lawsuit against the state to stop travel reimbursement to parents sending their kids to religious schools by the state of New Jersey. He claimed it violated both the states and the U.S. Constitution supporting one religion. So this case came up and became the landmark case that was going to set a precedence from here on out. And so in New Jersey, they had people that went to public schools. The kids sent their kids to public schools, but some parents decided they would send their kids to religious school. But they were have to pay for the religious school and travel to take the kids to the religious school, and so they had the state was reimbursing them for those because they are paying taxes into the school systems, even if they're going to a private school of some sort or religious school. But the Everson brings a suit saying, well, no, they can't do that. We should stop the state from reimbursing parents who are sending their kids to religious schools because it violates the state and the U.S. Constitution that they are supporting one religion. And so they take the Establishment Clause of establishing a state religion and say, oh, well, the very fact that you're supporting or giving people to go to religious school, that means that's an establishment of a religion. Well, and so the court takes that case and it overturns 150 years of what was practiced in the U.S. You had Christian churches meeting in government offices, for about 100 years. Thomas Jefferson went to church in the Capitol building where there was 4 church services held for some years. Even the Treasury Department had church services in it as well. And there was the public practice of religion allowed in Congress and other places. And to this day, you still even have chaplain there, and you haven't totally gotten out of the system. But it's with the Everson case that it's going to change the direction and bring up some a precedence to say, no, you can't have the public display and practice of religion, and the U.S. government can't be giving funds towards religious things, which of course the Constitution does not actually limit. So the interpretation put forward that overturned this 150 years of legal interpretation that allowed for the public expression of religion, even in government-supported entities, such as holding church services in the Capitol building. And it went contrary to the practice, contrary to government interpretation practice to that time period. And you had Thomas Jefferson, I think it was, who gave money to a Christian group to help the Indians. I think it was in like Wyoming or Montana. This was not seen as any problem early on. Now the ruling put forward that the government could not give any encouragement or financial aid to any religion. So this is quite a step away from the founding of a state religion or a formal official religion of the country. But if you look at the founding fathers' writings, that's not what they intended by saying, they will not have this official religion. But now it's being widened to interpret any kind of religious practice. There's a video here included with separation of church and state, which kind of gives a understanding of that, which could be helpful to you. But we haven't had much luck of these playing out. But I would suggest you watch this one to get an idea of what separation of church state's all about. The establishment of religion clause in the First Amendment means at least neither the state nor the federal government can set up a church. Now, this is in the findings of this court case. They agree that they can't set up a church, but then they add neither can pass laws which will aid one religion or aid all religions or prefer one religion over another. So what they've done is they've taken this establishment clause of establishing an official country religion and says, well, it can't even aid any religions. And neither can it force nor influence a person to go to or remain away from church any will. Well, that's the second clause, your freedom to practice however you want. Nobody, yes, that would be true. Or force them to profess a belief or disbelief in any religion. No person can be punished for entertaining or professing religious beliefs or disbeliefs for church attendance or non-attendance. But then they take it even further and they say, well, can't aid a religion, so no tax in any amount, large or small, can be levied to support any religious activities or institutions, whatever they may be called, or whatever form they may adopt to teach or practice religion. Neither a state nor the federal government can openly or secretly participate in the affairs of any religious organization or group or vice versa. So, and then this is where you get your separation of church and state. In the words of Thomas Jefferson, the clause against the establishment of religion by law was intended to erect a wall of separation between church and state. Now, the problem with that, they use that terminology from Thomas Jefferson, which is not in the Constitution, not in the amendments at all, Bill of Rights, nothing. It actually comes from a letter that Thomas Jefferson wrote to the Baptist Association in Connecticut. And it's used out of context. It's not what he was saying. He was actually saying the government can't interfere in the way you practice your religion. But now they're saying the government, separates itself from anything to do with religion. So they've misused how he meant to use the terminology anyway. But in either case, before 1947, in this case, you have things like in 1782, the first Bible was printed in the U.S., was commissioned by Congress and approved for use in the public schools, in schools. And in 1800, the Congress decided to use the Capitol as a church building. John Quincy Adams pointed out religious services are usually performed on Sunday at the Treasury Office and the Capitol. And so this removing religious activity, or the government encouraging religious activity or helping with various religious activity, was common up until this time period. And they didn't interpret the Establishment Clause to say there's this wall of separation or there can't be any overlap. And so this is a different direction being put forward with this Everson v. Board of Education ruling. Example of how it was before: in 1853, a group petitioned Congress to separate Christian principles from the government, asking chaplains to be turned out of Congress and military and Christianity from the public sphere. And so there is, you can see the influence of secular humanism and materialism, and there are already at this time period people and groups of people that are, taking a secular humanist perspective basically and trying to remove Christian influence out of the political and public sphere, which has gone even further today. So this petition went to the Judiciary Committee, and they looked at it and they say, well, no, this is not acceptable. You can't do this. And they said, just a quote from it, from their 1854 decision, had the people, the founding fathers they were talking about, during that revolution, a suspicion of attempt to war against Christianity, the revolution would have been strangled in its cradle. At the time of the adoption of the Constitution and its amendments, the universal sentiment was that Christianity should be encouraged, but not any one sect of Christianity, in other words. And so even Congress at that time realized that the founding fathers' intention was that Christianity was going to be an aspect of the founding of this nation, because they needed the moral teachings of Christianity. Now, it didn't matter, they weren't going to say, put one sect over another or one denomination over another. They just saying that foundational aspect of Christian morals and teachings were necessary, and they built it into the founding of the nation. And they, in fact, you see that the founding fathers will say that without that Christian moral foundation, this system can't really survive, and it was their perspective of it. So this is just one example before the Everson case. Another one, which occurred in 1892, was the Church of the Holy Trinity versus United States. This was a strange case, but it produced some interesting things. The immigrant worker was contracted as a rector and pastor for a church, and for whatever reason, the U.S. government claimed this was illegal under law, and so it went to court. And so the founding of the court case was that, well, it's not the intent of the legislature to prevent churches from doing this. In other words, they ruled against the United States, saying the church can do what it wants. If it wants to hire somebody, that's an immigrant worker, they have the right to hire them, and the legislature can't do this. So they were saying, no, this free exercise clause precludes you government from interfering with this. Now, the unique thing about this particular case is they cited 80 precedents for saying that the government can't, stop what the practice of religions, and so they list 80 precedents for their ruling, and you can look at these. I gave you a link for where you can look at these. So they ruled unanimously that Christianity was the basis of U.S. law and institutions. So it's very interesting. In 1892, they were still looking at Christianity as, like the founding fathers had, as a basis for U.S. law. A lot of the laws come out of a Christian perspective, like don't kill, don't steal, so forth. But they point out that in these precedents that there is all kinds of reasons why this ruling is not right, and that what they're asking them to do is to stop this immigrant ruler goes against the Constitution. And so there are a boatload of precedents. Here is just a little bit from it. If we examine the Constitution of various states, we find in them a constant recognition of religious obligations. Every constitution of every one of the 44 states contain language which, either directly or by clear implication, recognizes a profound reverence for religion and a assumption that its influence in all of human affairs is essential to the well-being of the community, the United States community. This recognition may be in the preamble, such as found in the Constitution of Illinois in 1870. We, the people of the state of Illinois, are grateful to Almighty God for the civil, political, religious liberty which he has so long permitted us to enjoy, and looking to him for a blessing upon our endeavors to secure and transmit the same unimpaired succeeding generations. So notice how Christianity is seen as undergirding what they're trying to do politically, civilly, and religiously. And then they also say, if we pass beyond these matters to view of American life as expressed by its laws, its business, its customs, and its society, we find everywhere a clear recognition of the same truth. Among other matters, note the following: the form of oaths universally prevailing, concluding with the appeal to the Almighty, the custom of opening up sessions of deliberative bodies, and most conventions with prayer and prefatory words of all wills in the name of God, amen. The laws respecting the observance of the Sabbath, with general cessation of all secular business, and the closing of courts, legislatures, and other similar public assemblies on that day, Sunday, of course. The churches and church organizations which abound in every city, town, and hamlet, the multitude of charitable organizations existing everywhere under Christian auspices, the gigantic missionary associations with general support and aiming to establish Christian missions in every quarter. So what they're doing is they're giving in their precedents, saying, look at how much religion is a part of our public institutions and what we about as the society and a system of government and so forth. And so they're saying, government can interfere and limit religions and how they practice it, whether privately or publicly, is basically what they're getting at. And so in the end, this thing, they say, these and many other matters which might be noticed to add a volume of unofficial declarations to the mass of organic utterances that this is a Christian nation. In the face of all of this, shall it be believed that a Congress of the United States intended to make it a misdemeanor for a church of this country to contract for the services of a Christian minister residing in another nation? So it's a really strange little case, but out of it, you get them citing all these precedents for the practice of Christianity within our society, within the public sphere, within political system, and so forth. And so realize that the Everson case is a real departure from the what was going on the first 150 years. And so as after the Everson case, though, you're going to continue to see this move towards secularizing the practice of religion in the public sphere. And so you get the Ingalls v. Vitale in 1962 ruling about the state-sponsored prayer. This was the New York Board of Regents wanted to have a non-denominational prayer to recite in school. And the prayer went like this: Almighty God, we acknowledge our dependence on thee, and we beg thy blessing upon us, our parents, our teachers, and our country. And the students didn't have to say it. They weren't even encouraged to participate, but yet this was taken to court, and you know, they felt that this was unconstitutional and couldn't be said, even though the prayer was not mentioning any particular religion or anything. But as other judges looked at the case, they said historically this was just a wrong decision. But when they decided that the school couldn't do this, they didn't cite a single precedence. So you have the one case which cites about 80 precedents. This one who takes the other, departs from that and upholds the Everson view. They cite no precedents in theirs. But again, this just shows the secularization that's going on at this point in society in the US. So you're in the 1960s at this point. You do, I'm trying to see here, there's another case here where I was looking at, see here, I'll get it here in a moment. That's going to take take it even further than that. But for right now, some of this is being reversed. This precedence that's being set by Everson is slightly being reversed, and we're going to see this in a little bit. A chief judge in the New York Court of Appeals said regarding Ingalls v. Vitale, not only is the prayer not a violation of the First Amendment, but holding that it is such a violation would be in a defiance of all American history, and such a holding would destroy a part of the essential foundation of American government structure. So again, you have a chief judge saying, look, this was a wrong decision, and just it goes against the First Amendment of free exercise of your religion. And if you look at American history, it goes against what's been happening in American history up until this time period. And, and he says it's against the essential foundation of the American government structure. So interesting perspective. Somebody disagreed with chief judge that disagreed with that decision. Okay. So in the Ingalls v. Vitale case, you see the term church is kind of being redefined. When it says not establish a church, it's basically saying, well, any religious activity, it can't be supporting any religious activity at all that's performed in the public instead of religious institution. So you see this gradual changing of what the meaning is of official religion, and so it's meant the government must not allow a public religious activity, but that's not what it originally meant. And so I would leave you another video to watch here on religious liberty and issues related to it. It's a good one as well. And then another case that falls on the heels of Everson and Vitale cases is the Wallace v. Jeffrey, which occurred right here where I am in Alabama, from a case with the public schools. Since prayer couldn't be used, as we've seen, they decided to set aside a period of silence at the beginning of the school day, instead of having a prayer. Well, this was taken to court as well, and it was also found that they couldn't do this either. because the mere suggestion that students might use the time for prayer made it wrong. So even a period of silence which could or could not be used for prayer was considered unconstitutional. You can see Justice White and other justices' dissenting opinion showed the precedence for not ruling against the silence. And so the dissenting judges would say, no, if you look at the precedents, this is not a good ruling. But yet that was the decision. And so couldn't even have silence time that might possibly be used for prayer. So you can continue to see this progression going through history. Now, personal prayer is allowed in the First and Second Amendments. Is no doubt about that. Public prayers, Congress still has prayers, as well, but some rulings in 2022 are changing that a little bit. You have more of a conservative Supreme Court now, and so you had a court case where in Kennedy versus Bremerton School District. The coach was praying at the end of football games, and it got taken to court, saying that he couldn't do that. And the court has ruled differently this time. And they said, no, the coach can practice his religion that way. He has freedom of religion and speech in this case. And they cite Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof, which according to the First Amendment, Coach Kennedy's legal team argued that the coach's expression fell within the bounds of speech protected by the First Amendment. 6 of the 9 sitting Supreme Court justices agreed. The Constitution, it was said, and the best of our traditions counsel mutual respect and tolerance, not censorship and suppression, for religious and non-religious views alike. This was Justice Neil Gorsuch wrote this for the majority. And so that we're seeing a kind of a reversal here. It went on to write, respect for religious expression is indispensable to life in a free and diverse republic, whether these expressions take place in a sanctuary or on a field, and whether they manifest through spoken word or bowed head. Here, a government entity sought to punish an individual for engaging in a brief, quiet, personal religious observance, doubly protected by the free exercise and the free speech clauses of the First Amendment. And the only meaningful justification the government offered for its reprisal rested on a mistaken view that it had the duty to ferret out and suppress religious observances, even as it is allowed comparable secular speech. The Constitution neither mandates nor tolerates that kind of discrimination. Mr. Kennedy is entitled to a summary judgment on his First Amendment claims. The judgment of the Court of Appeals is reversed. So an interesting change is going on, and going back to the first 150 years understanding of the free exercise clause and the establishment clause of the First Amendment. And so that's makes for some interesting things going on. All right. Then another case that has recently happened to is the Carson v. Mankin. This is the last slide of this presentation. As we sum up this this part of the historical development of secular humanism, we can see it here in society, but realizing that there is some obvious notion that now, in at least with the Supreme Court, who looks at the Constitution as, historically the way it was intended. This one concerned a Maine program that let rural residents who lived far from a public school attend a private school using taxpayer dollars, so long as the school was non-sectarian or not religious. Families who wanted to send their children to a Christian school challenged the program and said they should, be allowed to use taxpayer dollars as well, even though they're sending their kids to a Christian school. So they challenged this program that didn't allow for reimbursement to them, payment to them for the kids going to public school, even though they also paid into the tax system, which that supports public schools. And they said this excluding this religious schools violated their right to exercise their faith. Well, and here again, we see a bit of a reversal. The court sided with them, saying the main program amounted to unconstitutional discrimination against religion. And so here we're seeing again a reversal here in what's going on with these cases. And so that's a brief history of some of the things that have pushed secularism. But again, noting that Supreme Court now is looking back at some of those cases and making a distinction that Everson case and the Vitale case maybe isn't the standard anymore, and so this is creating quite a stir these days, particularly from the secularist point of view. And of course, it's reversal of Roe v. Wade on abortion. It feeds into this as well, and so that's part of what we're covering for today. We've got about 3 more sections of lectures on world religion and secularism and challenges of secularism in society, U.S. society today. So we'll be getting to that next time on the next lecture.